Hello everyone, welcome to ClearIAS. In this video, we'll be discussing about various constitutional bodies briefly. I'm Ujjwala Pulala, an educator at ClearIAS. Firstly, what are constitutional bodies? Those bodies whose formation is prescribed by the Constitution itself are known as constitutional bodies. They derive their powers and authority from the Constitution. A constitutional amendment is required to change any functions related to such bodies. So the first one here is Election Commission. EC is a permanent and an independent body. The formation of EC is prescribed by Article 324 of the Constitution. It is common to both central as well as state governments. The elections to Parliament, state legislatures, office of President and Vice President are looked after by EC. Composition. EC consists of a Chief Election Commissioner and other election commissioners. President fixes the number of election commissioners. The appointment of Chief Election Commissioner as well as the other election commissioners is made by the President. At present, EC consists of a Chief Election Commissioner and two other election commissioners. The term of office of election commissioners is 6 years or until they attain the age of 65 years, whichever is earlier. The powers of Election Commission can be divided into three categories. They are administrative, advisory, and quasi-judicial. So under the administrative powers, we have the supervision of the machinery of elections throughout the country, to prepare and periodically revise the electoral rolls, to notify the dates and schedules of elections, and to cancel the polls in case of any irregularities. So under the advisory powers of the Election Commission, it advises the President on matters relating to the disqualification of members of Parliament, and it advises the Governor on matters relating to the disqualification of members of the state legislature. By using its quasi-judicial functions, Election Commission acts as a court for settling the various disputes regarding the elections. Independence. Security of tenure is provided for Chief Election Commissioner. He can be removed from the office in the same manner as a judge of the Supreme Court. So how is the judge of a Supreme Court removed? The judge of a Supreme Court can be removed by the President based on the resolution passed by both the Houses of Parliament, and the two grounds on which he can be removed are either proved misbehavior or incapacity. This resolution passed by both the Houses of the Parliament should be with a special majority. And so what is special majority? Special majority refers to the majority of the total membership of the House plus majority of the 2/3 of members present and voting. Other election commissioners cannot be removed from office except on the recommendations of CEC. State Election Commission. So as we all know that the 73rd and 74th Constitutional Amendment Acts have added a third layer of government, that is the local self-governments, which include the panchayats and municipalities. So the elections to these panchayats and municipalities are looked after by the State Election Commission. Articles 243K and 243ZA deal with the elections to the rural as well as the urban local bodies. SCC consists of a State Election Commissioner who is appointed by the Governor. So when we read various topics in the polity, you have to make a comparison between the center as well as the states. So here in the case of constitutional bodies, you have to compare the state bodies as well as the central bodies. So in the case of Central Election Commission, what we have seen is the CEC is appointed by the President, whereas in the case of the State Election Commissioner, he is appointed by the Governor. So such differences as well as similarities have to be studied together. The removal of the State Election Commissioner is same as that of a judge of the State High Court, and the judge of a State High Court is removed on similar grounds and process as that of the judge of a Supreme Court. Union Public Service Commission. UPSC is the central recruiting agency of the country. Articles 315 to 323 in Part 14 of the Constitution talks about UPSC. UPSC is visualized as the watchdog of the merit system of the country. Composition. UPSC consists of a chairman and other members. The number of other members is left to the discretion of the president. Generally, the number of members in the commission, including the chairman, are 9 to 11. So these are the nitty-gritties you have to remember. You may get the question as the number of members excluding the chairman are 9 to 11. So such small minute facts also you have to keep in mind when studying such things. They hold the office for a term of 6 years or until they achieve the age of 65 years, whichever is earlier. Removal. The chairman and other members of UPSC can be removed by the president under the following situations. If he is adjudged and insolvent, while in office if he engages in any other paid employment, if he gets unfit by reason of infirmity of mind or body, and for misbehavior. In the last case, the president has to refer the matter to Supreme Court for inquiry. So what is the last case? It is in the case of misbehavior. And the advice of SC is binding on the president. Here again, you may get the question as the advice of the SC is not binding on the president. So you have to remember that the advice of SC in such a case is binding on the president. Independence. The chairman and the members of the commission enjoy security of tenure. Their conditions of service cannot be varied after appointment. Their entire expenses are charged on the Consolidated Fund of India. The chairman of UPSC is not eligible for any future employment in the Government of India or a state. Functions. Examinations for recruitment to All India Services, Central Services and Public Services of Union Territories are held by UPSC. All disciplinary matters affecting a person in civil capacity are dealt by UPSC. Assist the states in matters relating to joint recruitment. State Public Service Commission. So now you have to understand the similarities as well as the differences between UPSC and SPSC. Just as UPSC at the center, there is a State Public Service Commission in every state. Articles 315 to 323 in Part 14 of the Constitution deal with the various provisions of SPSC. So, the same articles deal with UPSC as well as SPSC. SPSC is considered as the watchdog of merit system in the state. Composition. SPSC consists of a chairman and other members appointed by the governor. So, in the case of UPSC, we have these members appointed by the president. The number of other members is left to the discretion of governor. One half of the members should be such persons who have held office either under Government of India or state for at least 10 years. The term of office is 6 years or until they attain the age of 62 years, whichever is earlier. So in the case of UPSC, the age is 65 years. Removal. The chairman and members of the commission can be removed only by the president. Although the chairman and members of the commission are appointed by the governor, they can be removed only by the president. They can be removed under the following situations. If he is adjudged and insolvent, if he engages in any other paid employment, if he is deemed unfit by reason of infirmity of body or mind, and for misbehavior. In the last case, the president has to refer the matter to SC for inquiry. So do you remember the nature of advice given by SC to the president in the last place? Independence. The chairman and the members of the commission enjoy security of tenure. Their conditions of service cannot be varied after appointment. Their entire expenses are charged on the Consolidated Fund of the state. In the case of UPSC, they are charged on the Consolidated Fund of India. The chairman of SPSC is not eligible for any other employment under the Government of India or state other than for appointment as chairman or member of UPSC or as the chairman of other SPSC. Functions. SPSC conducts all the examinations for the appointment to the services of the state. All disciplinary matters affecting a person in civil capacity are dealt by SPSC. Any claim for reimbursement of legal expenses borne by a civil servant are also looked into by SPSC. Finance Commission. Finance Commission is a quasi-judicial body. The formation of FC is provided by the Constitution under Article 280. It is constituted every fifth year or at such earlier time as President of India considers necessary. Composition. FC consists of a chairman and 4 other members appointed by President. The qualification of the members and the manner of the selection is determined by Parliament. They are eligible for reappointment. The 4 members should be selected from amongst the following: a judge of HC or one qualified to be appointed as such, a person with specialized knowledge in finance and accounts of the government, a person with wide experience in financial matters and administration, a person with special knowledge in economics. Functions. FC makes recommendations to the President on the following matters: distribution and allocation of the net proceeds of the taxes between center and states and also among different states, the principles that should govern the grants in aid to the states, measures needed to augment the consolidated fund of the state to supplement the resources of local bodies, any other matter referred to it by the President of India. Role of Finance Commission. The Commission submits its report to the President, who lays it before both the houses of the Parliament. The recommendations made by FC are only advisory in nature and they are not binding on the government. Remember this fact. Finance Commission is envisaged as the balancing wheel of the fiscal federalism in India. State Finance Commission. So it performs the same functions as that of the Central Finance Commission. So the Finance Commission at the center, the functions which it performs with respect to the center and states, similar functions with respect to the states and local bodies are performed by the State Finance Commission. The governor of the state shall after every 5 years constitute a State Finance Commission. Articles 243I and 243Y deal with the formation of this body. The composition, qualification of members and the manner of the selection is decided by the concerned state legislature. Functions. The distribution of the net proceeds of the taxes, tolls and fees between the state and local bodies. The determination of such taxes, tolls and fees to be assigned to the local bodies. The grants in aid to be given to the local bodies from the consolidated fund of the state. Measures to be taken for improving the financial position of local bodies. Any other matter referred to the Commission by the Governor of the state. National Commission for SCs. It is established by Article 338 of the Constitution. Initially, there used to be single commission for both SCs as well as STs. However, the 89th Constitutional Amendment Act of 2003 bifurcated it into 2 separate bodies. That is, National Commission for SCs was a separate body and National Commission for STs was made a separate body. Thus, a separate National Commission for SCs came into existence in 2004. Composition. It consists of a chairperson, a vice chairperson and 3 other members. They are appointed by the President by warrant under his hand and seal. So what does warrant under his hand and seal mean? It means that the President authorizes such an appointment and also his seal is present on the appointment. He does not delegate this function to anyone else. President determines the tenure as well as conditions of service. Functions. The following are the functions of the Commission: to investigate the matters regarding various safeguards provided for SCs, to inquire into the complaints related to the deprivation of the rights of SCs, to advise on the planning process for the socio-economic development of SCs, to submit reports to the President regarding the working of various safeguards, to make recommendations to union and state governments regarding the measures to be taken for effective implementation of these safeguards, to discharge such other functions as President may specify. On all the major policy matters regarding the welfare for SCs, the Commission is consulted by the government. National Commission for STs. It is established by Article 338A of the Constitution. The 89th Constitutional Amendment Act of 2003 inserted a new Article 338A. Thus, a separate commission for STs came into existence in 2004. Composition. It consists of a chairperson, a vice chairperson, and 3 other members. They are appointed by the President by warrant under his hand and seal. Their tenure and conditions of service are determined by President. Functions. The following are the functions of the Commission: to investigate the matters regarding various safeguards provided for STs, to inquire into the complaints related to the deprivation of the rights of STs, to advise on the planning process for the socio-economic development of STs, to submit reports to the President regarding the working of various safeguards, to make recommendations to union and state governments regarding the measures to be taken for effective implementation of these safeguards, to discharge such other functions as President may specify. On all the major policy matters regarding the welfare of STs, the Commission is consulted by the government. Scheduled Area and Scheduled Tribes Commission. So this is not a constitutional body per se. This is just a commission or the committee appointed by the President from time to time to submit a report on the administration of scheduled areas and welfare of the scheduled tribes. The President may appoint such a commission. President defines the powers, composition, and procedure of the Commission. The Union government shall give directions to states to take measures for the welfare of scheduled tribes. National Commission for Backward Classes. The 102nd Constitutional Amendment Act of 2018 made NCBC a constitutional body. This act inserted a new Article 338B into the Constitution. So, National Commission for SCs, Article 338, National Commission for STs, Article 338A, and National Commission for Backward Classes, the article is 338B. Initially, NCBC was a statutory body formed through the National Commission for Backward Classes Act 1993. So, it was granted a constitutional body status by the 102nd Constitutional Amendment Act in 2018. Structure. It consists of a chairperson, vice chairperson, and 3 other members. They are appointed by the President by warrant under his hand and seal. Their tenure and conditions of service are determined by the President. Functions. The following are the functions of the Commission: to investigate the matters regarding various safeguards provided for socially and educationally backward classes, to inquire into the complaints related to the deprivation of the rights of socially and educationally backward classes, to advise on the planning process for the socio-economic development of socially and educationally backward classes, to submit reports to the President regarding the working of various safeguards, to make recommendations to union and state governments regarding the measures to be taken for effective implementation of these safeguards, to discharge such other functions as President may specify. NCBC is the competent authority to look into the grievances of backward classes. Backward Classes Commission. So this is also not a constitutional body per se. This is a committee or commission appointed by the government. Under Article 340 of the Constitution, the government has the obligation to promote the welfare of OBCs. OBCs is a term used to define the socially and educationally backward sections of the society. The first Backward Classes Commission under the chairmanship of Kaka Kalelkar was established in 1953. The Commission recommended the reservation for backward classes in government services and local bodies. However, the report was not accepted by the government. The second Backward Classes Commission, known as Mandal Commission, was established in 1979. Mandal Commission Report. The Commission submitted its report in 1980. It identified as many as 3,743 castes to be socially and educationally backward. Excluding the scheduled castes and scheduled tribes, these castes constituted about 52% of the population. The Commission proposed for 27% reservation for OBCs in government jobs so that the combined reservation for SCs, STs and OBCs do not exceed 50%. Special Officer for Linguistic Minorities. So firstly, who are linguistic minorities? So linguistic minority is a group whose language is spoken by the minority of the population in the country. The formation of this office was prescribed by the States Reorganization Commission. This was formed by the 7th Constitutional Amendment Act of 1956, which inserted a new Article 350B in Part 17. The Special Officer for Linguistic Minorities is appointed by President. The Commissioner has its headquarters at Allahabad with 3 other regional offices at Belgaum, Chennai and Kolkata. The Commissioner is assisted by Deputy Commissioner and an Assistant Commissioner at headquarters. The Commissioner falls under the Ministry of Minority Affairs and submits its report to the President through Union Minority Affairs Minister. Role of the Commissioner. All the grievances related to the various safeguards provided for the linguistic minorities are looked into by the Commissioner. The Commissioner strives for providing equal opportunities to the linguistic minorities. He works for effective implementation of the various safeguards provided for the linguistic minorities. Official Language Commission. At the expiration of 5 years from the commencement of Constitution and thereafter at the expiration of 10 years from such commencement, the President shall appoint such a commission. The Commission recommends President regarding the progressive use of Hindi for official purposes. It also recommends the restrictions on the usage of English language for official purposes. Also, the Official Language Act of 1963 provided for setting up a committee on official language. Its purpose was to review the progress made in the use of Hindi language. Such a committee was set up in 1976. Comptroller and Auditor General of India. Article 148 of the Constitution provides for an independent office of Comptroller and Auditor General of India. CAG is considered as the guardian of public purse. Along with the Supreme Court, the Election Commission and the Union Public Service Commission, the office of CAG is treated as one of the bulwarks of the democratic system. Appointment. President of India appoints CAG by a warrant under his hand and seal. Now pause the video and try to remember the other appointments made by the President by a warrant under his hand and seal, which we previously discussed in this video. He holds office for a period of 6 years or up to the age of 65 years, whichever is earlier. CAG can be removed from his office in the same manner as a judge of the Supreme Court. Independence. CAG is provided with the security of tenure. His rights cannot be altered to his disadvantage after his appointment. All the expenses of the office of CAG are charged on the Consolidated Fund of India. His salary is equal to that of the judge of a Supreme Court. Duties. The duties and powers of CAG are mentioned in the Article 149 of the Constitution. All the accounts related to the expenses from the Consolidated Fund of India, Consolidated Fund of the States and Union Territories are audited by CAG. Also, the expenditure from Contingency Fund and Public Account of India and States are audited by CAG. The net proceeds of any tax or duty are ascertained and certified by CAG. CAG acts as a guide, friend and philosopher of the Public Accounts Committee. All the receipts and expenditure of bodies financed from the central or state revenue are also audited by CAG. The audits of any other body as and when requested by the President or Governor are audited by CAG. 3 reports are submitted by CAG to the President. They are Audit Report on Appropriation Accounts, Audit Report on Finance Accounts, and Audit Report on Public Undertakings. Role of CAG. The office of CAG secures the accountability of executive to the parliament in the sphere of financial administration. The CAG acts as an agent of the parliament and is responsible only to the parliament. Along with legal and regulatory audit, CAG also conducts propriety audit. So what is propriety audit? What happens is, in the case of propriety audit, CAG reviews and scrutinizes the decisions of the executive. So few of the decisions might be compliant with the rules and regulations, but still they may be incurring some wasteful expenditure. So such decisions are also scrutinized by CAG. Attorney General of India. Article 76 of the Constitution provides for Attorney General of India. He is considered as the highest law officer of the country. He is appointed by the President and holds office during his pleasure. A person who is qualified to be appointed as the Judge of the Supreme Court is eligible for the office of Attorney General of India. Duties of Attorney General: to advise the government on the legal matters referred to him by the President. To appear on behalf of the GOI in SC in all the cases concerning the government. To represent Government of India in the references made by the President to the SC under Article 143. To appear in High Court in the cases concerning Government of India when required. Rights of Attorney General. Attorney General has the right of audience in all the courts in the territory of India. He has the right to speak and take part in the parliamentary proceedings. However, he doesn't enjoy the right to vote. All the privileges and immunities available to a member of the parliament are granted to the AG. Advocate General of the State. Article 165 of the Constitution provides for Advocate General of the States. He is considered as the highest law officer in the state. The Advocate General is appointed by the Governor and holds the office during his pleasure. A person qualified to be appointed as a judge of a high court is eligible for the office of Advocate General. Duties and rights of Advocate General: to advise the government of the state on the matters referred to him by the Governor. To discharge those functions conferred upon him by the Constitution of India. He has the right to speak and take part in the proceedings of both the houses of state legislature. However, he doesn't enjoy the right to vote. Goods and Services Tax Council. GST Council is formed under the Article 279A. Its function is to make recommendations to centre and state governments regarding GST. It has representation from both centre and states and hence is a federal body. GST Council consists of the following members: Union Finance Minister as the chairperson, Union Minister of State in charge of Revenue or Finance as member, Minister in charge of Revenue or Finance or any other minister nominated by the state government as members. The decisions of the Council are taken by a majority of not less than 3/4 of weighted votes cast by the members present and voting. The weightage of the vote of central government is 1/3 of the total votes and the weightage of the votes of the state governments is 2/3 of all votes cast. It aims to uphold the principle of cooperative federalism. Interstate Council. Article 263 deals with the establishment of interstate councils for the coordination between centre and states as well as among different states. The President establishes such a council and also defines its duties and organization. Its decision is advisory in nature and is not binding. Composition. The council consists of the following members: Prime Minister as the chairman, Chief Ministers of all the states and union territories having a state legislature, Administrator of union territories with no legislative assemblies, Governors of states under President's rule, 6 central cabinet ministers nominated by PM. The council consists of a standing committee set up in 1996. Its members are Union Home Minister as the chairman, 5 Union Cabinet Ministers, 9 Chief Ministers. District Planning Committee. A district planning committee is constituted and given the task to consolidate the plans of both panchayats and municipalities. It prepares a draft development plan for the district. Article 243 ZD deals with the committee for the district planning. The composition, manner of election of chairperson and members is decided by the state legislature. 4/5 of the committee are elected by the elected members of panchayats and municipalities. The representation of these members is proportional to the ratio of rural and urban population in the district. In preparing the plan, DPC should consider the following: matters of common interest between the rural and urban local bodies regarding sharing of resources, infrastructure development, and conservation of environment. Extent and type of resources available. Metropolitan Planning Committee. A Metropolitan Planning Committee is constituted for every metropolitan area. Article 243 ZE deals with the Committee for Metropolitan Planning. The composition, manner of election of chairperson and members, functions, etc. are decided by the concerned state legislature. 2/3 of MPC are elected by the elected members of municipalities and chairpersons of panchayats. The representation of these members is proportional to the ratio of population of municipalities and panchayats. While preparing the draft plan, the committee shall consider plans of municipalities and panchayats in the metropolitan area, matters of common interest between the rural and urban local bodies regarding sharing of resources, infrastructure development, and conservation of environment, extent of the investments to be made in the concerned metropolitan area, objectives and priorities of the center and concerned state. So that's all for this video. If you want a video to be made on any other specific topic, please mention down in the comment section. Thank you, and please subscribe to our channel ClearIAS and press the bell icon. Have a nice day.